Lundy for the people.
First Assistant Public Defender Kalina Anderson with it on behalf of Mr. McGlashan. Mr. McGlashan, can you state your name again, please?
Brandon McGlashan, ma'am.
Your Honor, thank you again for the bench conference. At this time, the people are going to move to revoke the defendant's bond based upon the no contact violations that he's had with the victim in this case. I have previously disclosed to defense counsel the nature of the contacts, and there has been a new aggravated stalking case issued by my office that is in the process of sort of being sworn out and will be pending against the defendant soon. The defendant did have permission from circuit court to contact the victim regarding their child. However, the court has reviewed and has been submitted a police report that details the contacts he's had with her, which the people do believe go well past the scope of communications regarding the child, and are requesting at this time that he be remanded into custody because people have serious concerns that he will not leave the victim alone. He will continue to contact her. And while there is no threatening or violence alleged in any of these contacts, the people would certainly characterize them as harassing. And I do believe that it is appropriate at this time that his bond be revoked and he be remanded into custody. Thank you.
Response.
Thank you, Your Honor. In speaking with Mr. McGlashan, and we would indicate to the court that Mr. McGlashan does have permission to contact the complainant in this matter with regards to the child. A substantial amount of the conversations are about the child. They are to be, there were some communications to be made through the My Family Wizard app, but he was allowed to make contact via text if there was some emergency. There were some situations, without going into too much of an admission, but there was some situations where she was not responding on the Family Wizard. There were texts to get her to communicate with regards to the child. We would again reiterate, as we discussed in the bench conference, that there's no threatening behavior, no threats being made towards her, or any discussion about this particular case or anything to involving the case. My client has been the primary caregiver of the child, and while some of the things may not seem to be an emergency, given his relationship with the child and him being the primary caregiver, he had a heightened sense of concern with regards to some of the things that were being discussed. The parties are currently in divorce proceedings. It's my understanding that they are trying to come to some resolution, and that my client is really just looking forward to moving forward, caring for his son, and continuing to work. Your Honor has given him permission to leave the state. He is out of state right now. Is set to return on Saturday. And he does have another job where he will be working as an announcer at the water polo tournaments on Saturday and Sunday at the University of Michigan. So he is just asking for the court's consideration with regards to this. We've had substantial conversations as to how he is to handle any contacts that are made to him, and that he is not to respond. He's to get in contact with my office and allow us to deal with it without him responding. He understands that he's the one with the case and the PPO, and that, any contacts will fall on him. So he's just asking for some leniency from the court to be allowed to continue working and taking care of his child, and would ask that we adjourn this matter so that I can get the new case, see what's going on with that, and move forward.
Ms. Anderson, is there an opportunity for me to speak at all during this? Because
Mr. McGlashan, if the judge gives you permission, you can speak, but I would advise you not to speak about anything involving either case.
Sir, you can tell me. You can tell me what you want. And
okay,
your
sir.
Attorney gave you her advice.
Yes, she did. Your Honor, I'm not incriminating myself in any way here. I am verifiably, provably the victim of domestic violence from the person who got the PPO on me and kicked me out of my house. Miss Lundy, the DA, is the one who received that evidence and gave me a very cold and short answer when I asked why my attacker was allowed to stay in my home and get a PPO on me. At the PPO hearing where they received the PPO, I got into evidence and a FOIA request that my wife does, in fact, have a violent history, including a no contest plea and 2 arrests after that. I'm just saying, sir, she lied to kick me out. I'm sorry.
Let me just stop you for a moment. Because here's what I understand. You as to the child or children in common, you had been directed by the family court to only make contact with, yes, through My Family Wizard.
Yes, sir.
And that the only exception to that was then if it were an emergency.
Or time sensitive, yes, not necessarily an emergency, but time sensitive regarding pickup or drop off or something that needed to happen when she was dropping the kid off. Like, make sure he brings this or that because we planned on doing this, that kind of thing. And if she's not answering, I would literally sent OFW. And I'm an idiot. I shouldn't ever respond to anything, but I feel like
sitting judge. Hold on.
Yes, sir.
You wrote to her. A sitting judge signed a protection order.
She wrote that to me, sir.
Hold on. That I acquired evidence that you were lying to get the PPO and to throw me from my house. And I literally gotten those documents that afternoon before you would not have gotten the order, and you know it. And just to be clear, I have gotten video transcripts of every hearing so that we can remind the judge of everything you said and done, and that she's not just relying on my memory. Sir, as
Yes,
to
sir.
even the parameter, because I'm going to give you a shot to tell me, and there are more.
I know, sir.
To explain to me in your mind how that fits into the sort of expanded parameters that the family court gave you over our parameters.
Honestly, sir, I don't really have a lot to say about that. I was just trying to explain my
I don't
mindset.
want. Tell me, sir.
Yeah, okay. You said how my mind.
Answer. If you want to talk to me, then you'll answer my question.
Yes, sir.
Because I'm trying to figure out. First of all, you were supposed to have no contact according to our case. That gets expanded because you're in these family court matters. The judge in the family court, everybody's in agreement, has said no contact except through My Family Wizard. And the only things outside of that are to be certain things. What I just read you, tell me how that fits into any of those things that constitute an exception.
I just honestly believed as a victim, if I screamed the truth loud enough, someone would come to my rescue. I don't know the system. I don't have a lawyer.
But that is not, hold
yes,
on.
sir, I know.
That's not, that can't be a purpose for you contacting her.
I misunderstood the framing of the question. I'm sorry. I just
framing of
honestly
my question that I've said twice?
No, sir. Oh, sir. I'm sorry. I'm very sorry. I don't mean to agitate you. It's been a very long
I am
year.
not agitated. I'm just trying to give you every opportunity to explain to me some of these text messages
Yes,
and
sir.
how they fit within, you're before Judge Vandenberg,
Yes, sir.
how these fit within what Judge Vandenberg told you you could do.
I'm not 100% sure I can make a great case for that, sir. I've just been very willful and heartbroken and defiant, and I'm sorry.
Okay.
It will not happen again.
Sir, that was like one of the shortest ones. I don't
Yes,
know
sir.
what your legal fund has to do with an emergency.
With my legal what, sir?
Your legal fund that somebody's created for you. I don't know why that's an emergency.
Sir, I realize now through therapy that some of those things that I thought were things trying to get my wife to tell the truth before we had to come into this madness seem more manipulative and threatening than I had intended them to. I understand that. I'm working very hard to reframe things like that. All that stuff is literally just me
Yeah, but
trying
this
to
was
say,
after. Hold on. No. As I understand these emails, these text messages, these are occurring after everybody's told you what to do.
Yeah, I'm not disputing that, sir. Again, I'm trying to answer the question, but I feel like the question is changing as I answer.
My question's not changing. I'm
Okay,
trying
it
to
doesn't
figure
fit,
out.
sir.
We,
It doesn't fit.
sir,
It doesn't. Yes, sir. There's a delay.
if you want me to go through all of these and ask you for your explanation, I will.
I understand now what you're saying. Sir, I just want to do better. I have no explanation and it's not an excuse. I'm just heartbroken, and I was trying to keep my family together, and I'm not good at it. And it will never happen again.
Mr.
I swear to you.
Mr. McGlashan, again, I'm going to advise you just not to say anything further.
Yes,
It's not furthering our goal here.
Okay.
I'm
I just
good.
want to do better. I'm sorry.
I'm going to adjourn this matter 1 week out to the 9th, 2023, 9 a.m., where defendant's Zoom invite indicates. The court, having reviewed the text messages, understanding that it would be consistent with what Judge Vandenberg does, knowing the circumstances, allowing for emergencies, or even and giving the defendant here the benefit of the doubt, those things that are time sensitive. I read one example, but there are a number of examples through this thing that
Yes, sir.
are not time sensitive. They certainly, in this court's mind, don't constitute at all an emergency. And quite frankly, and I get what counsel's saying in terms of threats, maybe a physical harm or something like that. But quite frankly, when I read through these, they are threatening. They're threatening, and you can phrase it maybe in terms of harassment, but they're really threatening in terms of getting a response.
Yes, sir.
And I mean, the other person on the other end, you want to keep talking? I'll let you keep talking.
No, sir.
No, it's up to you. It's up to you. I'm going to give you every shot to tell me what you want me to know.
I don't want to get in trouble, sir. I'm not trying to make you angry. I'm sorry.
I am not angry. I am trying to give you every opportunity to tell me. I just don't like being interrupted, but that doesn't make me angry. So go ahead and tell me what you want me to say, because once I get going, I don't want to be interrupted.
I promise.
So you go ahead.
Yes, sir.
Go ahead. Tell me what you want me to know.
My answer to every question will just be simply this. I naively thought that if I can prove I am the victim of an assault and getting kicked out of my house, that none of this would matter, that it would all just kind of be voided from the point where I can prove she lied and I'm an idiot. I'm sorry.
You done?
Yes, sir.
Bottom line, these don't constitute emergencies. They don't constitute something that needs a direct response or an immediate response of her or would be time sensitive. They are really an attempt to get someone to say something. They're actually like baiting types of emails to get her to maybe say something, or posturing maybe for his divorce case. That's not the purpose, certainly, of Judge Vandenberg's order. If, even as the defendant says, I wanted to get somebody to listen, I don't think she's the one that needs to listen. If he thinks he's been the victim of something, then he needs to get it to the prosecutor's office, police, whoever the heck he needs to get it to. But there you go. There you go. What did I tell you? I'm done. I kind of tried to give my explanation. This defendant won't be quiet. It's March 9th, 9 a.m. Defendant's bond is revoked. Sir, when are you returning to the state of Michigan, or do you want me to come get you?
I will return Saturday morning to work at Michigan. Can it be Monday morning?
What time?
Please?
What time Saturday morning?
I think my flight gets in at 9:25 or something. I have to work at
Defendant's
12.
bond is revoked as indicated.
She beat me.
Defendant is.
How is this possible in America?
Defendant is to turn himself into the Washtenaw County Jail by noon this Saturday, which is the 4th. And sir, when I'm telling you, so we don't have to play around the edges of what I mean. If it's 12:01, you're going to have a problem with me.
Yes, sir.
12 noon. If defendant fails to return himself in, a bench warrant will issue for his arrest and he will be held without bond. I told you what rules I play by. You still wanted to interrupt me? I'm telling you the rules now. Try me. Thank you, counsel.
Sir, I thought you were done. I have a delay on my phone. I thought you were done. There's a delay. I'm in St. Louis.
He's still talking to me.
I wasn't interrupting. I'm in St. Louis. I
I'm
can't.
done.
Mr.
I'm
McGlashan,
done.
just log off, Mr. McGlashan. We'll talk later.